Ready?
I'm excited. Fucking thrilled.
This is going to be amazing. Ladies and gentlemen, hello. Welcome to episode 281 of Conservatish. Look how official we look right now.
We look like politicians.
We're on an episode of Crossfire, but like a creepy version because we have got one light behind us or ahead, where my bald heads are. Wherever you're listening, make sure you subscribe, share, rate, and review, or you're racist. I love you all very much. You can find me on Instagram at Peter_Feliciano. You can find me on TikTok. No, you can't. You can find me on Twitter at Rule62Peter. And, ladies and gentlemen, returning guest, Brandon Williams. Yay! Thank you so much for coming, sir. Good to see you.
Thank you. It's always a pleasure.
Yeah, we just got done shooting guns.
Yes, that was fun.
Yeah.
A lot of fun.
You apparently have built your own AR-15.
Yes, I did.
I don't know if you wanted to broadcast that, but
I don't care. It's, it's not a firearm, it's an arm, so it's okay.
Now, what's the difference?
Well, which one is protected by the Second Amendment?
Hang on, let me think of the. All right, a firearm. No, it's arms.
Yep. Now, what do you see? Now, I don't know. I'm new to Texas, but every single place I go into, there are legal.
Yeah.
There's like legal stuff. Can I curse on this? You mind?
Yeah, fuck yeah.
There's so much legal jargon on the windows, and it's like big. It's not like little tiny. It's like the whole. Like you have two long windows going into a place,
right?
And this entire right side is just legal mumbo jumbo,
right,
all the way down. And I guess people who live here don't really see it.
Nor do we respect it.
Yeah. But if you look at those are all firearms. They use, what do they use? They use the term firearms most likely.
Right.
And then even at the gun store, they use the word firearms. And then they also have the word handguns. And then they have a picture of a handgun, right? Which is interesting. So I've been noticing a lot of that. Boy, it's interesting. They just all the way down, the whole window, all the way. It's amazing to me. I've never seen anything like that.
Well, I mean, you've been to Florida, you've been to Indiana, obviously California.
Yeah, sometimes you see a little something and it's small, but the whole window in like 28 font print. It's with a picture of a handgun or arm or however you want to say. It's a whole different. I've never seen anything like it. It's cool. I mean, it's fine. I've been reading some of it. I haven't read all of it.
But let's illuminate that a little bit because what he's talking about is specifically businesses are not allowed to keep firearms out of their businesses unless they have that section, blah, 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 up on the windows. They're specifically asking, hey, Texans, I know you have open carry.
I think that's what it is. It's opened and concealed. So I haven't read all of it, but I've just been kind of noticing it a lot. I think it's a notice for open and concealed. And I think it's basically like open is this and concealed is this, and please do or don't, whatever. I don't really, I'm going to read more of them. I'm going to try to focus on it more. But yeah, it's just fascinating to me because you have the open and the concealed here. So it's like you have these two different worlds basically. I haven't seen any open carry, by the way. I've been here for about 10. No, I've been here for like 12 days.
Right.
And maybe I'm just asleep at the wheel, but I haven't seen any open carry myself.
Yeah, it's rare. I mean, number one, you're in Austin. You're not in Waco.
Yeah.
But also number two. By the way, just as a side note, did you know that sign is predominantly Austin is one of the main things for it, I'm sure. But I had Michael Cargill. Do you know Michael Cargill? He's the one who's been suing the ATF over all these different things.
I don't think so. Is he the Cargill guy? Cargill?
He is the Cargill.
Oh, okay.
Cargill versus
Merrick
Garland. He's the Cargill. Bomb stock ban, things like that. And so I had him on my show maybe 6 months ago. Good dude. And he told me, you don't need a license to carry guns, obviously, in Texas, but with a license, you can completely ignore those signs. Now, most of us do anyway. I would never, because that's an illegal thing. But a lot of Texans.
I would beg to differ, but I'm an interesting guest. I would beg to differ. You don't, those are all. It gets a little complicated, and the reason why is because the way that it works with business is you're entering into a commercial activity, and that commercial activity has a particular contract, and that particular commercial contract of which you are getting involved in actually supersedes the law itself. People don't realize that. whatever contract that you are, the reference on that is 15 USC 1. And if you look at 15 USC 1, it literally says that if anyone prevents you from getting into any commercial activity, and you can, if we want to go crazy, you could say like prostitution could be covered under 15 USC 1.
So don't bring your guns to the prostitute.
Anything you want could be covered under 15 USC 1. So 15 USC 1 is basically like anything that anyone does to try and prevent or startle or filter any commercial activity. If it's a corporation that is causing that flow to be hindered in any way, it's up to a $100 million fine. It's the largest fine I've ever seen in any body of law in all of America.
So if it's a corporation getting in the way of that business transaction?
Any commercial activity.
Okay.
Any commercial flow. That's why I said prostitution is technically a commercial contract. So that gets kind of interesting.
Sure.
If you are an individual, that 100 million goes to 10 million. I believe it's 10 million. So it's 10x for corporations. So it's very open and vague and verbose. So 15 USC 1 is literally anything anyone does to anything that prevents or messes up or hinders any commercial flow could be sued under 15 USC 1.
So you're saying that specifically in the context of wearing a firearm?
So when you enter into a establishment, you're basically walking in order to engage in a commercial contract.
Sure. Right.
Those signs or the windows with the wording that they have on there is essentially like, if you enter this building in order to willingly enter into a commercial contract with us, these are predetermined terms. And if you walk into the building in order to commercially contract with us, then you need to understand these are our predetermined rules before you even walk in the building. If you walk in the building, you've essentially agreed to these terms. Now the problem is that while that is true and while these signs are correct and while that's all fine and dandy, most people just don't. Nobody knows. Even the lawyers don't know that's how it really works. I don't even know how these things get on these buildings. To be honest, it must be through the code, building code or something, where it's just like you have to do this and no one knows why and the lawyers don't know and no one knows. But really, that's actually very true. You are entering into a commercial transaction. And you not having a open firearm, and then you could say like, well, I don't have a firearm, I have an arm. Exactly. So the thing is that you are not actually breaching the contract when you are open carrying an arm rather than a firearm, because it wouldn't be defined under the pre-posted contract of firearm.
Now, there's a lot to what we're talking about. I don't know if you guys, most of you, there's a lot of people who've watched our first conversation, and this is going to be the first time where you're talking about these things. Where I'm sad that we don't have the camera up here, that you could just if you look up 18 USC blah blah blah.
Yeah.
Because our first episode had a lot of detail and similar to. Essentially, well, we'll talk about that, but you essentially take your presentation, your contract killer, and you just bring it onto these various shows and talk about it, right?
We're not currently within the confines of my presentation right now.
Sure.
My presentation for this would be what is the wording of the Constitution, the Second Amendment, and we would pull that up, and you would see that it's the right to bear arms, and you will see that walk around for the next 14 to 30 days and see if you'll ever see that word used anywhere, including in the windows when you walk into a commercial establishment, on any paperwork, anywhere, and you will find that you will not see that word being used absolutely anywhere. I could even give you 90 days, and you will not see that word used anywhere. So you wonder where your Second Amendment went. It's actually right in front of your face.
What does Black's Law have anything regarding arms versus firearms? Any definitions?
Maybe I would need to pull it up and take a look and this and that, but really it just comes down to they are two different words.
Sure.
Obviously.
Right.
And it is a little strange, just to keep it very simple without having to pull everything up and everything. Why is it that they never, ever use the word arms? Why? Why did they never use the word arms? The ATF is not ATA.
Right.
It's the ATF.
That's some deep shit. Okay. All right. Very interesting. Now,
If there was no conspiracy there, then why wouldn't they use the word arms? It's like, okay, fine. There's no conspiracy. Use the word arms. They won't use it. They will not
firearms
use
don't
it.
melt steel beams. All right. Now, you're talking specifically. Okay. Now, your home built AR-15.
Yeah,
Is that an arm? Is that a firearm?
totally an arm.
Okay.
100%.
Now, is there a differentiation in did you need to register? And obviously not register, God forbid. But did you? Is there any differentiation in the definition when it comes to the quote unquote authorities, the state, whatever you want to call it, regarding those two things?
If they assume that it's a firearm and they call it a firearm and you never correct their assumption, in law, it's a firearm now.
Motherfucker. So you're saying it's not just around taxes, it's not just around citizenship.
This is the way all of law works. If they say, oh yeah, he's a resident of the state of Texas and he has firearms, and you go, oh well, and you start to that assumption.
Right.
So those assumptions have now become fact, and now we're arguing with inside of the confines of those assumptions being fact.
Okay, now.
So now you're like, oh no, well, I was actually carrying it in a box and it was in my trunk and blah blah blah. So now you're already subterranean. You've already been buried alive, and now we're having this very low level conversation.
Is it too late? Because I'm sure there are points where it's too late to back that up. I mean, obviously you can do contract killer stuff, as we talked about on your first episode, but is there a time where you can go, you know what? Never mind. By the way, this is an arm, not a firearm.
Well, the better thing is you got to realize, like, no one knows any of this stuff. So it's like, okay, the Second Amendment says I have the right to bear arms, but in this particular complaint that someone has filed, this lawsuit, it says firearm, 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 firearm. So it's like, is there? You can even play dumb too. It's like, is there a difference between an arm and a firearm? I'm not even sure if they would even know necessarily. It's like, okay,
Sure.
well, hey, if a firearm and an arm is the same thing,
Right.
then now the Second Amendment applies. And then I always like to laugh, because if somebody wants to say, oh no, the Second Amendment, blah, 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 let's say you have like a more of a left-leaning person, I always say, you know what, no problem. You can have it. But the Ninth Amendment says that just because something isn't specifically mentioned in the Constitution as something that I have a right to have or not have does not preclude that I do not have that right. Essentially anything that I would like to make my right, I can make my own right. So I give them the Second Amendment, and I say, no problem, you can have it. And then I pull the Ninth Amendment, and they're completely fucked. When you pull the Ninth Amendment basically says that it's very simple. It's like one sentence. But if I had to translate that into everything I've ever learned, it would be, if anything you would like to make your right, as long as it's not harming people, annoying people, swindling people, or making life less enjoyable or less livable or more difficult or more of oppressive, as long as it doesn't fit those categories, if you would like to make it your right, you have the right to make it your right.
Through an amendment?
The Ninth Amendment.
But I mean, do you need to therefore set up a new law or amendment?
No, the Ninth Amendment just says that just because it's not specifically delineated in the Constitution does not mean that it's not your right.
Okay.
But it doesn't say if you don't harm and swindle. It's like common law says that you can do whatever you want as long as you aren't harming and swindling people.
Right.
The Ninth Amendment says just because it's not mentioned in the Constitution doesn't mean you can't do it. So I mix those two ideas together, and I translate the Ninth Amendment as long as you aren't hurting people or annoying people or swindling people, then you can make anything your right, and it's your right.
Right.
Really. And that's really what I think the real truth is. So you can give up your Second Amendment right,
Right.
without having to worry about it.
Right.
Because you pull the Ninth Amendment, the Ninth Amendment's way crazier than the Second Amendment, in my opinion. The Second Amendment is like, the Ninth Amendment is like, I would like to carry an M60 on my back. It's kind of heavy, but I have a strap, custom strap that I made, belt fed, the whole thing. And it's like, really, technically, as long as you aren't. Now, it gets a little bit hairy, because let's say you did that in California, people are going to start freaking out. You are oppressing the populace by carrying around an M60, belt-fed M60.
By whose definition in this hypothetical?
It's a little bit complicated, because it's like, in California you'd have people screaming and running around, and you'd have all hell would break loose,
Right.
and there'd be people would be throwing tables down and ducking behind the tables, and
Right.
you'd have people running into buildings, and that's like, In Texas, I don't know what you're going to get. I have no idea. You might get a lot of happy faces and high fives. You know what I mean?
In parts of Texas, definitely.
So that's kind of why I say, like, you know, the way common law operates is it's the effect that you create. You know, it's a little bit complicated. It's like, okay, did I harm or annoy or agitate the local populace by carrying an M60 into San Francisco? That'd be an interesting conversation that would probably go on for a long time in a courtroom.
Right. Especially because the left is very quickly apt to go, well, gun does harm, right? So gun equals harm, right? Legally, do they have a precedent for that, or do you feel like
they would need to? Well, the burden of evidence falls on the prosecution in law. So if they are the word that would be used would be allegation. So if they are alleging that the gun has produced harm, you don't need to do anything, because now they have to go through the extremely difficult activity of now having to prove that of which they have alleged. So the definition of the term allegation means setting forth that of which the person who is setting it forth intends on proving.
Which is why a lot of times, like we said, we did a live stream with Elizabeth Galusho and Jamie Arrigo a month and a half ago or something, and there was some conversation regarding. By the way, if this feels like it's in the weeds, go look at episode 1 or the episode Brandon and I did. But also, this is LAWFARE. This is another one of those arrows in our quiver that a lot of people don't reach for because it's opaque and the quote-unquote powers that be like it to be opaque.
I'm not even sure they really know. To be honest with you, I don't really think...
Oh, really?
I really don't think anybody knows. I don't think anybody knows.
Even bars? Even bar card holders?
I think bars the worst of all, actually.
They're the most ignorant in your opinion?
Yeah. They're the worst. They just threaten and intimidate. That's all they do. Like if they had a set of cards, it would be threaten, intimidate, threaten, intimidate, and threaten. And that's their whole...
And then the last one is pick up a check. Yeah.
Maybe, depending on how well they I guess I know a lot of broke attorneys at law, so yeah, it's pretty.
Touché.
How well can you threaten and intimidate is pretty much, and they do a lot of backroom deals, and they do a lot of wheeling and dealing between their brethren, the other attorneys at law. It's a snake den.
Do you know why? This is something that I've been thinking about. Obviously, lawyers. It's a longer conversation, but lawyers are the least popular people in the world. We talk about it all the time. It's very colloquial, even at the very surface level thinkers, that lawyers are unpopular. Why did we decide to choose lawyers as the basis for the pool of politicians? Do you know how that started?
Because the bar card, I guess, because the bar essentially wanted to control everything. They kind of pushed everybody into that. But the real truth is this. Everyone walks around.
Is this one mine? This one's yours.
That's yours.
Okay.
Everyone walks around, basically, they look at the law, and the law is written in a way that's so complicated and convoluted that people immediately assume they can't handle it or understand it.
Right.
Now, they are under the assumption that the attorneys at law can and do understand it, and they think they have to go and hire an attorney at law in order to interpret the law in order to get some sort of lawsuit done as the plaintiff or defend themselves as the defendant. The hilarious reality of the situation is that none of the bar cards have any clue about the law at all, and they pretend that they do, and they wear nice suits.
All right. Okay.
So the thing is that the bar cards don't have a clue at all. And if you can look at all my lawsuits and you can log into Pacer and you can see, so all lawsuits are totally public, unless you have, let's say, for example, like a child's medical information, that would get filed as a private filing. But let's say you have 90 filings in a case. Just that one filing might be either fully private or partially private, but 90 plus, 95 plus, 98 plus of all filings and all lawsuits are all public information.
And it's Pacer.
It's pacer.uscourts.gov, I believe it is, and you can create a free account, and then if you wanted to go into the website's like 1994 or 1992 all over again. But if you go into, let's say you type in a case number and you pull it up, or a name, you type in someone's name like my name, and you can see that I've had some cases, and you can pull up the cases. You go into query, you go into docket query, and you just type in nothing at all, and it'll pull up all the different, every single filing, the initial filings that started the case, the responses to that, the motions to go into this thing or discover this, memorandums, affidavits, this and that, and you can even order transcripts. You can't order transcripts through Pacer, but I'm just saying, like, litigation is literally a completely public UFC octagon. Most of the time, again, if it contains children's medical information, there are certain exceptions to that. But vast majority of the time, everything is all literally, like, you could probably go on to a Wesley Snipes case, his original case in 2010, and you could see every single filing that ever happened in the entire case from the case's inception all the way to the closing of the case.
Does that include the stenographer's record or no?
If you wanted transcripts, I would imagine you would probably have to order those, but you can order those from the court.
It's available to anybody.
Yeah.
Even if I'm not involved in the case.
You would need to pay for them, yes.
Sure.
But yes, you could.
But it's probably
no
like
one
$25.
No, transcripts can be. I've known
really?
people $200, $300, $400 for a set of transcripts.
Okay.
So I can get a little pricey.
Right.
It's 10 cents per page if you wanted to download the written stuff that's in the case. But people just don't realize it is a full blown UFC octagon, full blown.
And the lawyers know this. I mean, obviously they know this because they fight like tooth and nail publicly in front of the jury, in front of the clients, and then they go to the fucking bar afterwards and talk shit and backslap.
It's actually much simpler than that. So attorneys, 90+%, except like trial attorneys and stuff like that, their main concern is billables.
What does that mean?
It means hourly, the ability to hourly charge their clients. They don't care about their clients. They love controversy. The term is controversy. They love justiciable controversy. They love all of this, and they want to create it, and they want it to go on as long as they can.
Sure.
For example, I'd say the biggest snake den within the snake den would be divorce. So the way divorce works is you have one bar card on one side. He calls up the bar card on the other side, and they actually work together to create additional controversy. The one says to the wife, you know, you could really get this and you could really do that and you should really go for it. And he's just like totally screwing you and blah, blah, blah. And it's the same thing that the other bar card's saying to the husband. And they fuel the flames. And then the two lawyers work together to drain both parties completely dry. Very common practice in the bar card world. So the bar cards, basically what they want is they want billables. So what they want is they don't want to win cases and they don't want to defend cases. They want to create as much as they can, and they want the case to go on as long as they can, and they want as much activity in the case as possible in order to justify them having to do something hourly in order to handle said case that's being generated, and then they can now bill their clients. And that's essentially the entire bar card world in a nutshell.
How do these niggas sleep at night?
It's literally like I am pretty well known for being quite friendly, being quite peaceful, especially when it comes to the government. The one demographic that Jesus himself, I'm not a Christian, but the one demographic that Jesus himself did warn us against is the lawyers. And I will say, not because I'm a fan of Jesus or I'm not a fan of Jesus, but I will say that from my own experiences, I agree with Jesus very, very much. I would say the one demographic of human being walking this earth that people should be concerned with and be very careful with is the bar card holding attorney.
Do they know this going in? Is there a culture? Obviously, once you start going into this, you realize, I mean, just like anything, doctors, whoever, corporate world, you get into that and you're now ensconced. I like that word, ensconced in a culture of, well, we're, dog eat dog, and we're fighting, and we're this and that, and, let's work together, and you gotta eat, you gotta get a house, you gotta blah, blah, blah. So you're in that culture of slowly selling your soul. But do you feel like maybe it attracts a certain type of personality, a certain type of psychopath, but have you met motherfuckers who are bright-eyed, bushy-tailed, I'm going to do the right thing?
Very rare. I mean, there's a course if you go on to howtowinincourt.com. You have a wonderful course that was written and launched in like 1994 or something by a guy named Dr. Graves. It's a course that you can buy called Jurisdictionary. It's I think it's like $300 a year to have access to the information. Wonderful course, absolutely fantastic course. It's basically how to win and litigate without using a lawyer, is literally. And he was a lawyer of 25 or 35 years experience, and he retired. I think he's in Florida now. He cares very much. He has a whole dictionary on there, specifically of legal terms that he's defined throughout his time period. He has videos. The website looks like it was launched in 1994 and has never changed since 1994. But still, it's mostly text-based. There's cute little icons and cute little cartoons for various things. It's a course that I have done. I've spent a lot of time on. I haven't even completed it fully, but it's something that I've spent a lot of time on. It's, in my opinion, it's one of the best resources that are available. So yes, there are bar cards out there. I just call them bar cards. There are bar cards out there that are not in that same category. I do have a feeling that Dr. Graves did care for his clients. He did want to win. He's very clear about that, even in his course, as to how to win and what to do and what you're looking for. But do I think that is common? Do I think no, I think it's extremely rare. I think if you are even able to find a bar card that thinks that way, it's a very, very rare, very, very unique. I think from my experience, having worked with and dealt with several, 10 plus of them so far, and we're just barely getting started, all they want is billables. And what's funny is they love you. They love you because you're coming in and creating the justiciable controversy. Right. So they act as though they hate you, but secretly they love you because you are the one who is generating all of their income.
Right.
So it's kind of a weird thing. And then you also got to think too, like if I wasn't suing people, then would the courts exist? So the courts love so you hear that pretty commonly. The plaintiffs are always the one that's kind of in the better position in the courtroom. Well, why is that? They are the one creating the work for the bar cards, and they are the one creating creating the courts, right? Yeah, so it's an economic. I believe it's an economic situation.
Similar to the gripe, justifiably set forth by people who say, oh, well, the pharmaceutical industry, or the doctor industry, the Western hospital industry wants you to stay sick. They profit off of you, but it's the same type of thing. You're bringing in business. Of course, it's going to now favor the plaintiff.
Yeah, and the other thing is that as the plaintiff, you file the initial complaint, which is the first thing that triggers the lawsuit. They respond to the complaint with an answer, and then you are able to respond to their answer. So you're kind of, as the plaintiff, usually you're in the first position with most things. And as the plaintiff, you kind of do have a slight upper hand a lot of times in things.
Like a football coin flip. Yeah.
So I like being the plaintiff. I like initiating litigation. You also got to think too, like let's say, for example, someone initiates litigation on you and then you file what's called a counterclaim, which means that, so the way a counterclaim works is very simple. Let's say you get a complaint and it says 1, 2, 3, 4, 5, 6, 7, 8, and they're all allegations. Again, what's an allegation? Setting forth that of which you intend to prove. Right. So they're saying we're setting forth all these things that we intend to prove. And then the answer has to go line by line. So it's 1. And the way Dr. Graves teaches it, which is the way I think is correct, is you answer each line item affirmed, denied, or I don't have enough information to know the answer. You just keep it you shut your mouth. You don't say a lot, right? The bar cards love to talk and talk and talk. That's all billables. Right. But the way that it really should work is 1, affirmed, 2, denied, 3, affirmed, 4, denied, 5, not enough information to know the answer to this question or statement. 6, denied. 7, denied. 8, denied. 9, affirmed, right? You don't ever see that very often, but that's how Dr. Graves teaches it. And it's cool because it's like you have 1, plaintiff and defendant entered into a contract to exchange peaches for oranges. Now, if that's true, you would say affirmed. But a lot of times what they do is they go on and on and on and on and on, which is very stupid. Dr. Graves teaches you don't do that. So if you go on and on and on and on and on, you say, back in March of, plaintiff and defendant decided to go into a contract with real property. They met on Tuesday, the 23rd at 2:30 p.m.
Some of the I saw the documentation of Marilyn Manson was suing the woman who claimed that he had raped her or something like that, and the Google Doc of that lawsuit was like 70 fucking pages or something crazy like that.
Yeah, that's not great. That's usually just a lot of filler generally.
Right.
You don't want to. I don't. That's a lot of billables right there. Right. So the thing is that the problem with having really long paragraph items like that is that if anything in that entire paragraph is deniable, you can write denied on the whole paragraph. So I can go, if the paragraph's this long and there's one teeny little part that's denied, you can just deny it on the whole thing. Boom. Okay. Now, if you cut that up into individual paragraphs,
right,
instead of one big paragraph, you have, let's say, 13 smaller ones. They have to affirm or deny on each individual point. So
does this man recommend A, B, 1B, 1C, 1B?
It would be like 1, plaintiff and defendant entered into a contract. 2, plaintiff and defendant entered into a contract for real property, real estate. 3, real estate property is located at 32117 Spider Monkey Lane. 4, contract was signed by both parties. You could even go that far. And then 5, contract was signed by both parties on March 16th of... You can go that. That's how I do mine. That's how I do mine.
Now, what is the benefit of that? Obviously, you're saying it
separates. They have to affirm, denied, or I don't know for each individual line item. Okay. Now the way it works is when you do let's say American Express sues you. They have the complaint. They have these different line items. Now, your response, you have to answer the complaint. You can do some stuff to try to get around answering the complaint. But that's all bar card stuff. That's all like trying to get billables. Really, generally, you just answer the complaint. If you're not trying to get billables, if you're defending yourself, then you're not trying to get billables. So why would you try to do all these other things that you could do? You could do a motion to dismiss in that time period. That's how you can prevent having to answer it. You can also do a motion to strike. So you can have let's say there's 20 different points. You can file a motion to remove certain points, but the rest of the complaint stays intact.
So that it's not even in the allegation.
You can remove points of that's called striking. So if you strike, it's like point number 4, point number 16, and point number 19 are stricken. And if that's approved, then you can strike certain points. So when you have to answer, you don't have to answer those particular points.
Right.
A motion to dismiss is to get rid of the whole thing. And then there's another type of motion that's basically a motion to clarify. So you can say the whole complaint isn't very clear, or these particular points are not very clear. This is called, this is what Dr. Graves says is the flurry of motions. So it's like you get the complaint and then you can go, and you can do motion to dismiss, motion to strike, or motion to clarify, essentially, right? Now, once that's all exhausted, you have to answer. Now, usually they try to do all that in there for 2 reasons. They're just trying to throw a wrench in there that really shouldn't work. But if anyone accepts it, or if the other party doesn't know what they're doing, they can somehow get an easy win doing it that way. But mainly it's billables. Right.
Again, going back to that Octagon reference, that UFC reference, it doesn't necessarily go what's right and wrong. It's who can win this.
It's billables.
Billables, right.
It's an excuse to work.
Right.
That's why everybody hates lawyers. They don't know why. It's because all they want to do is just have an excuse to work. That's all they care about.
Right.
Literally. The only time you won't see that is obviously someone going after someone for damages, and then they only get paid if they win. You're not going to obviously have billables in a situation like that, so that's not really a concern. But besides that, it's just billables, right?
Right.
You can call up a lawyer right now and say, "Oh, I have this case," and blah blah blah. "Oh, you have a really good case. Oh, yeah, this is really good." It's going to cost $500 an hour for me to look over all the paperwork, but I think you have a really strong case here. That's what they're going to tell you, because they want 2 or 3 hours of billables. And then they'll say, I really just don't. I'm looking over everything, and I just really don't. But they knew that from the beginning, or they just didn't even look at the paperwork at all.
Right. But
they
thank you
just
for
call
the
you.
$1,500.
Thank you for the $1,500. Yeah, which is really pathetic. It's a very small. It's like $1,500 is like, especially in the world of litigation, $1,500 is like that's like a coffee in litigation. I mean, if you really can perform. I mean, you could become a millionaire or a billionaire faster in litigation than almost anything in the world, which is kind of sad in a way.
Right.
But the thing is that I've got probably $410 million in cases right now going, and I've barely even gotten started.
Right.
By the end of this year, we'll probably have over $1 billion in cases going.
Right. Now, let's jump into a little bit of that, because specifically in the world of lawfare.
But real quick.
No, please.
So when you answer the complaint after the flurry of motions,
This is again in the scenario where you're being
sued.
Okay.
So it would say answer, affirmed, denied, affirmed, denied. I don't know. I don't have enough information to know. And then below that, you can now write a counterclaim. You would write counterclaim. And then if it was 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 23, counterclaim. And then at 24, you would write, you can sue them back within the lawsuit. And now you have them suing you and you suing them in the same lawsuit with a countercomplaint. And that's kind of how it all works. So you can actually turn around and sue anyone who sues you.
right.
That's kind of, I wanted to circle all the way back to
Right.
the counterclaim. So let's say you're getting sued by American Express or any of these banking institutions. If you know the information that I teach on how all the banking stuff works and the negotiable instruments and how endorsements work and kind of the banking system, you can counterclaim absolutely anything they ever do to you. You can sue them right back, 100% of the time.
Right.
Any loan, mortgage, anything under the sun, moon, and stars, when you know this information, you can counterclaim and you will win. It's very easy to win.
Now, as far as you will win, does that mean, because we talked about it a little on that live stream, in the allegation period, you can essentially claim anything. I remember you saying, like, you can essentially
You're
claim
setting
anything.
forth that of which you intend to prove. Now, if you set forth a bunch of crap that you can't prove, you're going to look like an idiot, and
Right.
you could be, at an extreme level, you could be hit with like fictitious filing, or vexatious filing, or even contempt of court. Because you're basically at that point you're ridiculously using the legal system as a weaponization essentially at that point.
Sure.
And at that point you will get hit with what's called sanctions, which is like all the bar card's favorite term in the whole world. Sanctions. Like you'll never hear more from a bar card than the word sanctions, which basically is a really polite way of saying is threatening you. That's really what it is.
So in that allegation period, what's the exact word? Allegatory? What is it?
Alleging, allegation.
But the period of time itself.
It's complaint, answer.
Okay.
Complaint, flurry of motions, answer, depending on if you want to go down the road of a filing for a motion for dismissal or a motion to strike or a motion to clarify.
Now, say I was suing Meta. We talked about it. I'm just using that as an example. And I definitely want to get into some that you're going through right now. But in that allegation period, what you're saying that a lot of times you'll win because why? Because these companies, these bodies don't want to deal with it?
No, with the banking stuff, it's very, very easy to win. With something like Meta, it's a little different because let's say, you entered into a contractual commercial transaction. The problem with a commercial transaction like that is that the commercial transaction itself is higher on the scale than even like the codes and laws themselves. Right in the, I think it's Article 1, Section 10 of the Constitution says that, no party shall get in the way of the, obligation of and performance of contracts, which is literally 15 U.S.C. 1.
Right. Like
literally comes from the Constitution. Like, I'm not kidding. And that's why I laugh, because some people are like, the Constitution and this and that, the Constitution and this and that. And the thing is that it's all there. The Constitution is there. It's just the wording, it might be a little different. The wording might be a little of this. Like, you wouldn't say Article 1, Section 10, and you wouldn't say the infinite capacity to contract. You would say 15 U.S.C. 1.
Right.
Same thing.
Okay, so maybe the Meta thing is a bad example, but let's specifically, in that allegation period, let's take a banking one. what is the impetus for them? Why do they kind of get stuck in the weeds and say, let's just settle, or let's just win, fuck it? Like, what is the defeatism there? Is it mostly around? That looked like it was fun. Is it mostly around? Dude, my back is all the time like that.
Yeah.
What is it mostly around? What is their reasoning behind that?
Well, when you realize how the promissory note system and the bill of exchange and how all the money is created and how all this is, so a Federal Reserve note is a note. Shocking. A note means it's a promissory note.
Right.
Shocking. A promissory note is an unconditional promise to pay. And the term pay means to perform or fulfill a duty or contract or obligation. Payment doesn't mean to send in Federal Reserve notes, as most people think it means.
Right.
It actually means to perform on a duty, contract, or obligation. Okay. So to pay is to perform.
Right.
And what's funny is that a promissory note is an unconditional promise to pay. Now, every time you place your credit card into a credit card reader, you are producing a promise to pay. That promise to pay can actually be exchanged at what's called the Federal Reserve discount window for Federal Reserve notes. And the way that you sign
Right.
the promises to pay that are manufactured when you use your credit card, that is actually called an endorsement. And people usually say, oh, yeah, that word I see on the back of my checks, endorsement. There's actually a second word, which is spelled indorssement, that no one has ever seen or heard of.
God damn it. Okay, continue.
So if you look inside of UCC, so the Uniform Commercial Code Article 3 is all about negotiable instruments. What are negotiable instruments? It's promissory notes and bills of exchange. So all of our money and all of our financial system operates under what's called UCC Article 3. And there's going to be people in the comments that are going to say, well, certain states have not fully taken on the UCC, blah, blah, blah. Yes, I understand that. But when you look at the states and you look at the different laws and stuff, they don't say it's the UCC, but when you read the various things that are in their codes, it's just the UCC, but it's not named the UCC. The UCC Article 3 operates everywhere. It operates everything. Some states have said like, oh yeah, UCC. And some states have said no to parts of the UCC, but then they have statutes that are essentially the parts that they said they didn't take on. I don't know why. It's just kind of goofy. Basically, essentially, UCC 3 is the financial Bible, essentially, of everything that we're doing. Okay. Now, UCC 3 spells endorsement INDORSEMENT. I personally believe, from my own research, that when you're producing a negotiable instrument and releasing it, it's INDORSEMENT. When you're receiving a negotiable instrument and you're signing it, it's ENDORSEMENT. I'm not totally sure on that, but just from everything I've done and everything I've studied. So when you go to Starbucks and you put your card in and it pops out and it says sign here, you're not actually signing, you're actually endorsing. You're actually bringing that negotiable instrument or security or currency, technically it would also fall under currency, into existence. And the way in which you sign is the way in which you are releasing that instrument. The problem is that what everyone's doing is they're just signing. If you don't state the payee on the negotiable instrument, you're doing what's called a blank endorsement, which is the same thing as a blank check. You're releasing that security without any condition. Now, what the banking institution is doing is they're taking that security that you just released without any conditions, and now they're taking that security that you just manufactured out of thin air, they take it to what's called the Federal Reserve discount window, which you can literally type into Google, and there's tons of information. You can even look up all the banks that currently have window access. You can look up what date they were given window access. You can even look up another section, which is requested access. So every single new bank or federal credit union that has requested access to the Federal Reserve discount window, there's a whole section for that. What date did they request? Is it pending? Was it approved? What date was it approved? It's all on the Federal Reserve discount window website. And if you would like to, you could go and get Federal Reserve discount window access yourself right now. All you need to do is just fill out what's called an OC-10 agreement. Mm-hmm. You can type in OC-10, which I believe is Operating Circular 10 agreement. You can download the whole agreement. You can read it. And then at the very end of the OC-10, it says that when you submit your OC-10, you also need to submit a few additional pieces of information, documents. And you can actually get your own Federal Reserve discount window access. So what they do is they take these promissory notes that have been released with a blank endorsement, and they actually go to the Federal Reserve window all digitally through FedWire and everything. And they write what's called an application for notes, which comes from 12 U.S.C. 412. And they use the promissory note you just manufactured, and they call it a collateral security. So they say, we have this collateral security that Peter just created when he just went to go buy his coffee that he signed without any conditions. We would like to swap this collateral security that Peter just created in order for Federal Reserve notes. And what's funny is the way that the system works is they will always say yes. There is no no doesn't exist. As long as there is a collateral security, they will swap it for Federal Reserve notes. So
collateral security meaning the one that you signed.
The one that you signed.
Without condition.
So you created the currency.
Okay.
You gave it to the bank without really knowing. You basically released it without condition to the bank. The bank takes it and swaps it for Federal Reserve notes. So it was already paid for, and then you go and you pay a second time on something that was already paid for because you didn't claim it. If you claim that initial security, there's two ways you can actually handle it. Way number one is if you endorsed every single security without recourse. Without recourse is literally a banking term that says that if you take this and you process it, I don't have any responsibility for anything or non-payment or anything. So it's basically like a personal insurance policy.
Okay.
Once you take this and once you process this, I'm out. Any difficulties, any non-payment, any non-balanced, anything, accounting or anything, you can't come back to me. I'm out. I'm out forever on this instrument. So you can sign every single thing that you do. You can go buy a car. You endorse every single document all the way through the whole process without recourse. If they process those documents, which is a whole other story because they actually can't not process it. They might say they're not going to process it, but you can actually litigate and you can force them to process it. But if for some reason they don't notice it or something like that, they'll give you the car. And then what happens is a month later, they call you. Oh, Mr. Feliciano, your original paperwork, there's something off on the signature. We need you to come in and re-sign it. And we always say, what's wrong with it? I don't know, Mr. Feliciano. I was just told to call you and have you come in and re-sign the documents. They don't know. The people calling you don't know. They're just told there's something wrong with the signature on the original documents and the person needs to come in and re-sign it.
Right.
The thing is that if you never re-sign those documents or if you just go in and just sign them without recourse again, you never have to pay for the car.
Get the fuck... God damn it.
You have there's no responsibility for you to ever make payment, and they can never come after you for non-payment. Now, does that mean they won't come after you for non-payment? No. They may still. Nobody knows any of this stuff, so they're going to assume you don't know. Right. They're going to assume that some internet guy told you to do it. You don't really know what you're doing.
Only the Federal Reserve knows this?
Well, the thing is that the reason why I learned of this is because we started ordering original copies of people's mortgages. And the mortgage companies were sending a lot of my people processed documentation. Because even the mortgage companies don't know how any of this works. On the processed mortgage documents, it says without recourse when they give the original promissory note as collateral security to the Federal Reserve for Federal Reserve notes. Always it says without recourse. Every single time. I've never seen the bank give an original collateral security to the Federal Reserve that did not say without recourse. Always says without recourse.
So the banks know this.
Of course.
Okay. You just used bank to bank.
Yeah.
You used the law, legal, or whatever, but you use that same tactic.
It is a collateral security. It pays for itself. So when you manufacture a promissory note and you give it to the bank without recourse, they're already getting paid. The promissory note pays for itself. It's all self-paying. You don't ever need to pay for anything, really, technically. So the thing is that they were already paid because that original promissory note is the collateral security. So when you do without recourse, and what's funny is they can't say no. That's a whole nother subject. They actually can't say no. So if you do without recourse and they say, oh, we're not going to process this, and they freak out, which they are starting to do a little bit. It's starting to get bigger now. They can't do that. They have to process it. So the definition of accepted in banking terms is accepted by delivery. So once you slide that paper across the table, once it's delivered to the individuals that are supposed to process it, it's technically in law considered accepted. So another thing you can do is you can actually mail stuff certified or registered mail. And when they sign for it, them signing for it is legal proof it was delivered,
right?
Which makes it legally accepted.
Okay, but does that? I'm getting maybe confused. Does that transfer that legal that need to pay that debt? Does that transfer? It's not debt, right?
Well, Federal Reserve note's a promise to pay. What you manufacture is a promise to pay. It's all promises to pay. It's not real money. So real money, by definition, is gold and silver coins. You can even look in UCC 3-104, and it's basically like the title for all of UCC 3. It says right in UCC 3-104 that UCC 3 is all about negotiable instruments and does not embrace money. Literally says it in black and white right there.
Wow.
Does not embrace money. This is not about money. We're not talking about money right now. We're talking about negotiable instruments.
Okay.
Negotiable instruments are only two things: promissory note or a bill of exchange. Promissory note is defined in UCC 3 as an unconditional promise to pay. And a bill of exchange defined in UCC 3 is defined as an unconditional order to pay.
I'm going to set people on fire. Okay. All right. No, this is good. All right. You okay to go a few more minutes?
Of course. This is fun. I'm having a blast.
Yeah,
so when you get sued from Amex,
right,
and they say you didn't pay your bill, all your bills are paid. Your mortgage is paid. Everything's paid because you promised to pay. If you promise to pay, it's all paid. Because the original promise to pay is a collateral security, and they went and they swapped it at the Federal Reserve discount window for Federal Reserve notes.
It's already paid.
Well, it's even crazier. So let's say you get a loan for $60,000, but it's at 5% interest for 30 years, a mortgage. Let's just make up some numbers, right? So the value of the original promissory note is actually the value of the fully matured instrument. So it's the $60,000 plus the 5% over 30 years. So they'll say right in the promissory note, blah, 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 times 5% for 30 years, and then what you'll pay at the end. And they're like, oh, we're helping you by calculating all this for you. Right. No. The reason why they're doing that is because the $93,658 final number, that's the actual value of the promissory note. So you can actually buy a home, endorse the original instrument in a certain way, forcing... So a blank endorsement is an endorsement that does not state a payee.
Right.
You can do a special endorsement, which does state the payee. So you could do the following. You can say, let's say, for example, it's Chase Manhattan Bank N.A. Without recourse, pay to the order of, Chase Manhattan Bank, comma, N.A., below that, by, B-Y, : that's where you sign your signature, line, and then below that it would say Peter, middle initial or whatever, Feliciano, comma, and you could say like banker or representative or whatever you want, right? Now what happens is you're saying that this instrument of which I am manufacturing is payable to you guys. You guys can go to your Federal Reserve window and you can, I know your little game, boys. I know exactly what you're doing. But
they're already
doing all this. But when you do it that way, you're stating, I know the game, don't F with me, and it's without recourse. So when I know what you're going to do, and when you go to the window and you get your money, you can't come back to me for any payment. You've already gotten paid. It's a done deal. I'm walking away with my car, my house. But what's crazier is that the original loan is $60,000. They're getting paid $93,658 by swapping that instrument. So what happens to the remaining $30,000, $36,000? So you can actually give them only a small part of that, and you can actually have the rest of it come back to you. You can actually get paid for buying a house.
All right. Big picture. Big picture. Let's step back.
And they can't stop you at all. There's nothing they can do to stop you.
Now,
if they try to stop you, you can sue them for damages. And now that's not going to happen overnight. They're going to kick and scream like you've never seen anything kick and scream in your whole life.
Because they know the stakes.
They know they are getting dragged into the wood chipper, and they are going to do everything in their power to slow down that process.
Right.
So it's not going to, they're going to go ballistic if you litigate over this. But the cool thing about litigation is now they've breached the contract and they've stolen your negotiable instrument, which is up to 25 years in prison. So now we have criminal, we have damages. Now not only are you're going to pay me the $36,000 for all the interest that should have been on the original instrument, but now you're going to pay an extra $2 million for damages. Plus you're going to get the DOJ involved for criminal case, and now you're going to start prosecuting to start putting in people in prison on top of everything else. You can go that far if you want to.
Which is why 20 minutes ago, you said when it comes to these litigations, when it comes to banking, they just want to, okay, fine.
That's why I love banking, because I know I can always win big in banking. But it's like, okay, imagine going to the casino and you have 100% win on everything. Like you literally couldn't lose if you tried on any game in the entire casino. To me, that's litigation in banking. Everything else, like divorce and this and criminal and that and this and that, it's like it's all over the place. What you can and can't win. To me, banking is 100%. You could just close your eyes and point the gun in literally any direction, anywhere, and pull the trigger, and you're always going to hit a target.
Wow. Okay.
When you know how the game is played.
When you know how the game is played. Now,
so they sue you for not paying your American Express or not paying, or they foreclose on you for not paying your mortgage.
And then you can deny, approve, and then at the very end.
And then you counterclaim.
Motherfucker!
And then they are like epically fucked. Like epically fucked. Because not only are you going to walk away with a free house, but you're going to get millions of dollars for them fucking with you. Not going to happen overnight. I don't want to make it seem easy. It's not going to be. They're going to be kicking and screaming and absolutely frenetically, totally freaking out for probably many, many months. But if you just drag them through that, then at the end you will get damages. You will get all of it. You will get and people always say, like, have you done this? I am in the process of doing this. You can see all my cases on WilliamsandWilliamsLawFirm.com. I have not won a case, okay, but I will tell you the law is very, very clear. I have a million different, very black and white. There's no way this thing is getting. There's no way. There's no way you can lose. Now there is a way you can lose, which is to give up on month 9. That's a way you can lose. But if you're wanting to go and you're willing to go as long as it takes, there's no way to lose. You literally cannot. It's physically impossible to lose. You can't. There's no way.
Okay, now when this was set up, because I also wanted to talk about bar shit, but fuck that. Maybe it's the similar thing. Where and when and why was the bar system set up?
To give this illusion that you have to have this thing. I don't know. I mean, you don't need a bar card to do anything with the law at all. I don't know. It's just a club. It's literally just a club. It's like the tax system is just a club. People don't realize that either. Taxes are just a club. You basically elected to become part of the club. It's the same thing for the bar. The bar is you elected to become part of the club.
And we, knowingly or otherwise, as non-bar card holders, have elected to, what's that word, where you delegate our responsibility to a club.
There's two different types of attorneys. And what's so funny is that you can even look inside of my cases, and at first they freaked out and said it wasn't true and this and that, and then now they're starting to come around because they realize that I'm not stupid at all. There's two different types of attorneys. Okay, there's an attorney at law, and there's an attorney in fact. An attorney at law is a bar card. An attorney in fact is an attorney that operates off of a contract, which is called a power of attorney. People have heard that, right? Mm-hmm. So let's say grandma's kind of losing it. She's got dementia.
Right.
She's not allowed to, the notary, a good notary will check a person's lucidity, and they won't allow someone who's kind of gone to notarize documents, because generally what's happening is someone's taking advantage of that person.
Right.
So you want to get the notarization for the power of attorney done prior to the point where dementia or something like that becomes more advanced. Otherwise, it becomes a non-legally binding power of attorney. But as long as you have somebody who's doing all right or kind of still lucid, once a power of attorney is notarized, like I said earlier, the contracts are God in the eyes of the law. So the thing is that if you have a power of attorney,
higher than law,
if you have a power of attorney signed, you are an attorney in fact, right? Now, an attorney at law, if you look up the definition of the word client in Corpus Juris Secundum, a client is basically, in terms of an attorney at law, it's an infant or person of unsound mind. So the way that the law looks at an attorney at law relationship is you're basically either a child or you're retarded. And there's a legal definition of retarded means you can't actually handle like normal adult day-to-day activities required to even live in this world, essentially.
This is specifically client.
Yes.
That's what client
That's the word
means.
client, right? So because you can't step into a courtroom and you can't speak on your own behalf and you can't just literally just do simple things of defending yourself against allegations and simple things, right? You're basically saying that I'm too scared, I'm a baby, I'm retarded, I'm this. So the attorney at law represents you. You've heard that term, represent. So what that means is they present on your behalf. Now, when you do that and you sign those documents and you take on an attorney at law, you sign away all your rights. Infants and persons of unsound mind do not have rights. You can't even operate. You become a ward of the court.
Right.
So all attorney at law relationships turn you into an entirely worthless individual that cannot claim your own rights. So you see these people who are like, I have rights and blah, blah. No, you don't. Sit down. Fucking shut up and sit down. Once you took on that attorney at law relationship, you waived all of your rights by doing that. An attorney in fact relationship is entirely contract based. So you can waive specific rights in the contract, the power of attorney with an attorney in fact, and you can also reserve all your rights, and you can reserve certain rights, and you can do anything you want. And the way that the law interprets it is whatever's in the contract is what is true.
Right.
So the only rights that my clients in an attorney in fact relationship waive is the right to grant jurisdiction, just to give jurisdiction away like it's, ice cream. And the other thing is to sign any instrument with a blank endorsement. Every other right under the sun, moon, and stars, everything you've ever heard, everything you can even think of, as per the 9th Amendment, is all reserved underneath my power of attorney. Everything is reserved. All rights are reserved except those two. And I make them give those rights up on purpose because that actually defends my client. When you do it that way, what's happening is that I don't represent my clients. I assist my clients to present themselves through a contractual obligation of which I am the fiduciary or the trustee, and they are essentially the beneficiary in that relationship, and I have a fiduciary responsibility. And there's literally the federal level and at the state level, they actually literally have what's called the Power of Attorney Act. The Power of Attorney Act literally says pretty much everything I'm telling you in even the statutory codes, how there can be an attorney in fact. You can even look on the fucking APA website and you can find information about attorneys in fact and how it works. This is like not even secret. And you'll see in my lawsuits, they're like freaking out and saying that I'm like practicing law without a license, and I'm doing all this stuff, and like. But what's funny is I just like laugh. I'm just like laughing at these people. Like what they do is they expect that you don't really know. They expect that you heard from some guru to do this, but you don't really understand it. And then they start threatening you, and they're hoping that they're gonna rattle you.
Yeah,
that's all they do. I'm telling you, like the bar card way. If the bar card was a martial art, it would just literally be to try and antagonize you, threaten you, or intimidate you in an effort to try to throw you off. And if they see that they can throw you off in any area and they see that you're rattled at all, they go whole hog into that, trying to take you out. That's the whole bar card martial art, A to Z. That's everything. You say like, oh, no, it's the law. They don't know anything about the law.
right,
They can copy and paste stuff, but even the stuff they copy and paste, they don't understand.
right.
You could spend a month studying law and like the basics of law and like basic information, and you're gonna know more than bar card.
What about motherfuckers who take shit like pro bono?
Well, that's a whole. Those are like trial professionals.
Okay.
When you start getting a trial attorneys and with that, that's like real shit.
Okay.
Most attorneys just want to copy and paste some stuff. They've already sent it a million times, like a bankruptcy attorney or a divorce attorney. They take an old document they've already submitted 5,000 of. They change the names out and they submit it. They don't even know what they're doing, but it works. They get through it, and they're like wear their nice suit and blah blah blah. And the client's like, oh, gee, thank you so much, blah 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 blah. But they're just billables. It's all billables. Until you start getting into trials and stuff like that. Like trials, you have to actually win.
Right.
Everything else, you don't have to win anything. You just some papers fly around, and I was working so hard, and they bill by the hour, and they got billables, and that's it.
And because they have a bar connected degree, that means that justifies all of this.
It's all an
overspending,
illusion. That's why they wear the nice suits. They have the nice offices. They look like banks. It's
Right.
funny that banks and law offices kind of have the similar.
Yeah.
It's all an illusion. It's all.
Right.
It's the illusion of power and professionality. But they actually secretly don't know anything. That's why they're so egotistical. The egotism is they have to reverse the fact that they know they are charlatans. So the egotism is all part of all of that. It's a inflated illusion in an attempt to, because they know they are charlatans.
That was me in my fucking dating in my 20s.
Yeah.
I was like, I was insecure, and so I was just like, yeah, fuck you, bitch, blah, blah, blah. I just, I acted like I was superior. I wanted to be this perfect, like, mix of like a, what did I always go to? Pimp scholar. I was pimp scholar, you know what I mean? Like, yeah. But, then I did some more healing work. Anyway, we'll start wrapping up, but a lot of this is important, and we talked a little bit about in our first episode, and everyone should go to onestupidfuck, by the way, .com. But we've talked a lot about the spiritual angle, the mental, emotional, the 5,000-foot view of why you do what you do. Where is your drive behind a lot of these things? I know we've talked about it maybe offline, but where is your drive behind these things? Because obviously you give away the contract killer. You help people. You going and talking at Confluence, blah 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 blah. Where's the drive behind it for you? What?
Well, like I said, you want cash. I mean, I'm learning infinite money, so like that's I produce. What you don't realize is that we're all walking around saying, I need to make money. Well, the thing is, you're making money. You're not making money. Money is defined as gold and silver coins. It does not embrace notes, bills of exchange, or evidences of debt. Currency and funds, literally in the definition, those terms do embrace notes, promissory notes, bills of exchange, and evidences of debt. So you are not making money. People say making money, and they think that means to transfer already manufactured negotiable instruments called Federal Reserve notes from another location to my bank account or my location. But what's funny is that you are literally manufacturing out of thin air currency and funds all the time. Every single time you use your credit card, you are manufacturing a promise to pay, and you are endorsing that promise to pay, and with a blank endorsement, bringing brand new currency into existence. And the way that how the guys at the top they operate is, they set the system up to where we're the ones inflating the money supply. They're not actually the ones doing it. You see, they've set it up to where it's reverse. We are burying ourselves. Every time we use our credit cards, we are the ones creating the currency or funds. Thus, we are the ones that are inflating the money supply. That's very effed and very evil, but that's essentially the world that we live in, right? So they take these blank endorsed promissory notes and then expect you to send in additional promissory notes on top of that. And we happily do it. In fact, we're prideful of it.
Right.
We're prideful, like, oh, we pay our bills and we have a great credit score, and the whole thing is set up to be prideful. We're prideful of being United States citizens. We're prideful of paying our promissory notes with promissory notes on top of promissory notes, which are promises for nothing at all. They don't promise anything. It's just a dead end. There's nothing there.
Right. Because they specifically said they're not connected to gold and silver.
In 1971 was the official end of any connection at all to precious metals. And what's funny is you can go onto a website. It's WTF happened in 1971.com. And it's hundreds and hundreds and hundreds of charts that show that the downfall, the expeditious speed of the downfall of the United States of America, all these graphs, hundreds of graphs, all started in 1971. And the only thing that happened in 1971 was the official final blow that completely disconnected gold and silver coins from negotiable instruments, which created a system where infinite money is possible.
Right.
They can infinitely produce all of the negotiable instruments they want for any end. Education, transgenderism, they have infinite cash flow.
Right.
Just by endorsing instruments and understanding promissory notes and swapping those notes with the Federal Reserve at the Federal Reserve discount window via an OC-10 agreement.
Right. So, as far as your spirit behind it, a lot of it is,
just truth.
We talked a little bit about, the rebellious spirit you grew up.
Well, people want cash so they can have girls and fame and everything else. But the thing is that you can get fame and girls and everything else without having to necessarily have cash. I never, ever would have imagined, but doing what I do and giving it away for free drives women absolutely bonkers. Women always have the same. They always have the same reaction.
The
all the information, the videos, everything. Right,
okay.
the free
I thought
course.
you meant giving it. Anyway, continue.
So girls always say the same thing to me, and I didn't know any of this. I just started asking them, right? Like, why are you so into me, right? What is it, And they always say the same thing. They go, what you do, and it's so amazing, and it's like, oh my God, and you're so certain, and you have so much confidence, and you just, this and that. But then they say, and you give it away for free. And they just like, every time, bro. I'm telling you, it's like if I had to break down what women find attractive in me into a 100%, and I had to classify what fills up that whole 100%.
Sure.
The first 50% is like everything, like confidence and this and that, and like knowledge and the way that I use terms and the way that I do this and my humor and the self-deprecating humor.
You're a pretty
and my
good
art.
shot.
All of that is like 50%. The entire second 50% is just the fact that I give it away for free. Drives them bonkers.
Right.
Like out of their mind, literally.
Right.
And I didn't know that. I just thought the information just needed to be free, period. There wasn't a whole lot of thought. I just knew like karma and this and that. It'll be fine. I just thought people need this.
You certainly couldn't rail against bar card holders if you were being a cunt as well.
Yes.
Right.
And also, when you charge, it's considered commercial. So there is an interesting legal benefit to not charging, is you become truly untouchable. Because if it's not commercial, there's really nothing they can do about it. And commercial is defined as there have to be some kind of monetary exchange. So the fact that I give everything away for free is actually hilarious, even on the legal side, because there's literally like nothing anybody can do at all for what I'm doing. They can go on the litigation side, which I do charge for that. But the thing is that the contracts that we have for the litigation side is so specific and so long and so in depth. There's no way. There's literally no way you could ever get. I mean, it's just 15 USC1, like $100 million. Like if they hit me at all, trying to come after me at all for any commercial transaction, I would immediately counterclaim for 15 USD 1 and I go for 100 million immediately.
This nigga.
Like there's literally no way. There's literally no way.
Right.
Literally no way.
Right.
No way. The thing, that's why I like to talk about the system, and I like to talk about the fact that everything that people think they don't have, they actually have. They just don't realize it. And actually, the system is built in a way where when you really realize how it all works, you have more rights than you even think the Constitution gives you, actually. Right. You are a walking fucking juggernaut. You are unstoppable. Up to the point where you start harming, annoying, and
oppressing,
people.
Right?
Swindling, not being clear in your contracts, leaving out important terms and conditions of a contract. These are things where all of that fun and all of that freedom ends. But everyone agrees that's where they're supposed to end. That's why what we're talking about right now is common law. That is common law. That is your Wild West films.
Right.
If two guys want to shoot each other, then the sheriff's usually fine with that as long as the children and the kids go inside and there's no stray bullets and like don't be shooting at the buildings,
Right.
But if two men want to kill each other, go for it. It's just like the sheriff just becomes sort of a referee, and the way he looks at it is you have the ability to contract as you see fit. You have the ability to contract as you see fit. Now, neither of you motherfuckers have the right to shoot this kid or this child or this mother or even this man over here. But you two have the right to shoot each other all you want if you understand the contract, you understand the terms of the contract, you understand that bullets could kill your body, and you could be buried over here in the cemetery, and you both have the ability to shoot each other and shoot each other. That's the movies depict it very accurately. That is common law. And to this day, we still have that same system in play. It's just more convoluted and complicated, but it's the same exact system.
Is it a separate system?
Technically, yes, and there's a lot of talk about this, but really, when you start studying the statutory system in great depth, not really. It's just different terms. It's pretty much integrated into the system. It's just a lot more complicated and convoluted.
And when you sign away your rights to, when you become a baby or an invalid or whatever, to someone's, you're essentially giving someone power of attorney. They're now able to do whatever the fuck they want.
They could put you in prison. The literal bar card attorneys sign what's called penal bonds. The bonds are what actually physically places you in prison. The lawyers can sign them on your behalf, which is why the court gives you a lawyer for free. They can't put you in prison unless you have an attorney at law. They can't physically even put you in prison.
Interesting.
The attorneys sign the bonds that place you into the prison.
Right. This is a lot. And there's obviously a lot more. But I especially if you're listening right now, if you're watching this right now, obviously subscribe, share, rate, review, leave a comment. It helps the algorithm, guys. Faggotry. I just needed to fit at least one. I already said one nigger. Might as well say faggot. But
burn it down, huh? Burn it down.
No, I mean,
burn it down.
People. I've been saying fucking. When I first started the show, I was like, "Am I gonna say nigger?" You know what? I need to be 100% open. So I said, and happily, I've been thanked. I've literally been thanked on my show for saying nigger instead of the N-word. A black friend of mine was like, "Thank you for saying nigger instead of the N-word. It's so insulting." And I'm like, "Well, if he said right." I mean, I would have said it anyway because it's my fucking mouth. But okay. But specifically, if you're listening to this, understand, because I was talking to you about this experience I had a few days ago, or yesterday, when I posted something essentially saying, hey, everybody, calm down. Don't lead with the chin. Like, don't get baited into January 6th 2.0 because you're fucking emotional. And then I had a bunch of fucking groypers fight me online. No, you don't get it. Christ is king, so that means I need to fucking I need to ruin the movement and get our guns taken away because I feel something. Fucking turds. There are many arrows in our quiver. And to eschew logic to that point where we see this as a binary option, I'm either 100% in the system or I burn it down, is not like, you gotta stretch this mind, and this is why I appreciate the work you're doing.
If you want a shocking frame exploder, really. It's not even a frame shifter. It's a frame glass shatterer. Everyone listening to this should look up 18 USC 8, which is called Obligations and Other Securities of the United States. And you won't believe me, and you can read that, and it'll probably take you 30 to 90 days to process it. The government is saying that all bills, all promissory notes, all Federal Reserve notes, everything, your utility bill, your credit card bills, your mortgage, your hospital bills, your car bills, everything are actually obligations or other securities of the United States. Every bill you've ever gotten, the government is supposed to pay it, and they want to pay it. You try to get them to pay it, and they freak out, but that's the law.
Now, property of United States, is that why citizen of the United States located in District of Columbia, you're now roped into paying the debt that they owe?
Yeah, so the whole all caps corporation thing,
Right.
that all caps corporation is like their own child, and that's why all the bills of exchange and promissory notes and everything have that child's name on it, and everything that child manufactures is an obligation or other security of the United States. You don't have any bills. The only bills that you've ever really had are bills that your buddy Tim wanted you to pay because he fixed your TV, and it's like a personal thing and it's not a big business. That you every single bill that you get in the mail are actually obligations or other securities of the United States. We actually intend on I just about 3 or 4 days ago I had this huge realization. We're actually going to start bringing the United States in as defendant on the cases that we're counterclaiming or plaintiff claiming to the banking institutions, and we're actually going to sue the banking institutions and the United States because the banking institutions are coming after you for a debt that doesn't exist because the original promissory notes were collateral securities. But even beyond that, the United States is allowing this to happen when it's actually an obligation or other security of the United States. So not only is everything already paid, but it's not even yours even on top of that. So it's actually just goofiness on top of goofiness, actually. The idea that there is debt or the idea that you could have debt is a completely impossible false illusion. It is literally physically impossible.
Right, because it's all promissory.
You cannot have debt. It is physically impossible. You could get 500 mortgages. It is physically impossible. It is physically, spiritually, mentally, legally, financially impossible that any of that is unpaid or debt or your debt or all of that is completely impossible. Physically, mentally, spiritually, emotionally impossible. It's all an illusion. Right. It's just glass and mirrors.
Right.
Doesn't exist. It can't exist. It physically cannot exist. The only way it can exist is they can assume you don't know this information. They can say it is your debt, and then you can agree. But what is that ultimately? It's a contract.
Right. You
contract is senior to law. You've allowed a private contract to become senior to law.
But
and when you don't do that, the law becomes senior, and the law says that's a collateral security, and that's an obligation or security of the United States.
But as we're talking about it, similar to those, just to tie it back to something we talked about in the first episode, and what you talk about in Contract Killer, is this isn't something to be angry with them about. This is something to be like, oh, I didn't correct you. Here's a correction.
Yep.
And they go, okay. And they move the fuck on.
They have to.
Right.
They might play games or play dumb, but like the very rapidly when they realize what they're going to do is you give them this, and then now what are they going to do? They're going to be bar cards. What does a bar card do? Intimidates, threatens, and says the word sanctions over and over again like it's some kind of sexual safe word. That's what they're going to do. They're going to say all this, see if they rattle you. If you don't get rattled and you move forward and you're just like chill and you don't care at all whatsoever and you know what the game is, then that's when they crumble. It's always the same interaction.
Right. God bless us. Okay. So here's the thing, ladies and gentlemen. Wherever you're listening, leave a comment, share, rate, blah, blah, blah. But go to onestupidfuck.com. And where can people find you on? You're also one.stupid.fuck or whatever.
Yeah. So on my website, you can get to my law firm website. You can get to all my personal documents I give away for free. You can get to all the links of things that I learned from the State National Theory page, which is in text form. A lot of the information, like a book, basically. You can sign up for the free Contract Killer course. You can get to my YouTube, my Instagram, my Facebook. Everything is available at onestupidfuck.com. It's like a central hub.
Okay. Fantastic. Thank you very much. Brandon Williams, ladies and gentlemen. Love y'all very much. Go find me on Instagram at Peter_Feliciano or at Linktree/Peter Feliciano, Feliciano. Bye, ladies and gentlemen.